Welcome to the first of the series of podcasts in Module 2 on marriage and family. I'm Donna Cooper and I will be taking these 3 podcasts. So the objectives of these sessions to give you an idea of the historical background to our current Australian laws in relation to marriage and family. You'll see that historically our marriage laws are linked to English case law and have their origins in Christian values. We'll also look at how changing conceptions of concepts of marriage and family in Australia have impacted on the law and are currently impacting. And we'll also look at how at times the law also drags behind what's actually happening in our society and our community. We'll also have a podcast on divorce and just touch on some basic concepts about how to apply for a divorce on behalf of your client and some of the important time limits. And during the course of these podcasts, we'll also provide answers to the tutorial questions that you've been asked to prepare. So going on to our first module in relation to marriage, and just stepping back for 1 minute, I guess, also in relation to our changing conceptions of family, having a look at our different families in these photos, which really represent, I guess, the types of families that are now recognised in Australia. But originally we'll see that the law really only recognised a nuclear family, such as the one portrayed in the photo of Tony Abbott and his family. However, we've certainly become more inclusive to recognise a whole range of families. So for this podcast, we'll now turn to marriage. And I just wanted to point out at the outset that there has been a distinction in law between a legal marriage between a man and a woman, a heterosexual de facto relationship, and a same-sex de facto relationship. During the course of this family law subject, you will find that historically there were different levels of rights for people depending on what type of relationship they were in. And a legally married couple and a couple of a marriage with children originally were the ones that had legal rights under family law. However, in more recent times, the law has opened up to include legal rights, for example, to obtain parenting orders, to apply to the family court for property settlement in relation to de facto couples, and that's heterosexual and same-sex. But it's just probably important from a historical perspective to be aware that this wasn't always the case. So now we're going to turn to the 4 main elements of marriage in Australian law. It must be a voluntary union in the vows that are required for a marriage ceremony. We talk about the union lasting for life. It must be a monogamous marriage, that is one partner at a time. And in Australia at the moment, a legal marriage is only between a man and a woman. Now, looking at that first element in relation to a voluntary union, you will see in relation to the law that there are instances in which a marriage may not be based on a voluntary union. And for example, one of the parties could apply to the court, for example, for a decree of nullity of the marriage to say that the marriage never existed. Now, we don't actually have time to cover that in this course, and it's a very rare application that is made if you're a family lawyer. But if you're interested in those areas, have a look in Chapter 3 where they are discussed. It is quite an interesting area. Now, under the Marriage Act, which is the act that is relevant to marriage, Marriage Act 1961 and it being a Commonwealth Act, the marriageable age is 18. However, if people want to marry and they're under 18, they can obtain both parental consent and the consent of the court. If they can't obtain parental consent, they can ask the court to give consent in its place. Now, going back to those 4 elements, we'll just have a look at the next 3 elements. So the first one was for life, and I guess although that's usually something that's said in the vows of marriage, we're now aware in Australia that many marriages don't last, and there is quite a high divorce rate. For example, in 2013, there were 47,338 divorces in Australia. Of the divorces, 47.4% of those divorces involved children under 18. And the average duration of the marriage was 12.1 years. So I guess for family lawyers, there is quite a high divorce rate. It's often quoted as 1 in 3, which is, I think, an approximate figure, and it results in quite a lot of work for lawyers in the area of family law. Now, to the exclusion of all others, I guess marriage is to be monogamous, but I guess as we all know, for some people in some marriages, that's not the case, and people do have affairs. But certainly in Australia, it's not legal to have a polygamous marriage unless actually you've entered into that type of marriage overseas. It can be recognised in Australia, which I guess is a bit of an interesting point. Now, as we said, currently in Australia, marriage has to be between a man and a woman. And this has become quite controversial in recent times, as many places around the world have changed their laws to allow for same-sex marriage. Now, just to understand where our definition of marriage came from, in 2004, the government inserted a definition of marriage into the Marriage Act. Before that, it had just been assumed that this was what marriage was: the union of a man and a woman, to the exclusion of all others, voluntarily entered into for life. Now, in 2004, the reason a specific definition was inserted was because same-sex couples were marrying overseas and then wanting to register their relationship under the section that provided for registration of overseas marriages. So the government inserted this definition and also amended the section dealing with registration of same-sex marriages to provide that same-sex marriages entered into overseas could not be recognised, and that was section 88, capital EA. Now, this legal definition of marriage is derived from an Old English case, the case of Hyde and Hyde, Zance. It was actually a case where he was looking at a marriage that had been in the Mormon religion, and Lord Penzance concentrated on the fact that the marriage had to be between one man and one woman to the exclusion of all others, because in that case the marriage had potentially been polygamous, as the husband, being a Mormon, had the potential to take another wife. Because of that, Lord Penzance held that that marriage was not valid in English law. It had been a marriage entered into in Utah in the United States. So it was from that case that our current definition comes from, and His Honour said, marriage is understood in Christendom is the voluntary union for life of one man and one woman to the exclusion of all others. Now, I guess that definition has stood the test of time. It's been adopted in Australia, and at the moment we continue to use that definition. Although I think in England they have legislated to allow same-sex marriage, and there has certainly been a strong push for that change to the law in Australia. Now we can have a look at some other cases just briefly to see and understand more these historical origins of marriage. This English case of Corbett and Corbett, it concerned a person who had gender reassignment surgery. So the party had been born a boy, George Jamieson, but had gender reassignment surgery to become a female, April Ashley. The application was by Arthur Corbett for a decree of nullity to the court that his marriage to April Ashley had never been a valid marriage because it had to be a union between a man and a woman, and he was arguing that April Ashley was not a woman under the meaning of the particular Marriage Act in England. The reason he wanted to argue this was that he didn't want her to be entitled to any inheritance. He was a very wealthy man. Now in that case, I guess just as an aside, the judge had to determine whether April Ashley was a female. He used a very medical 3-step test, and he decided that she was not, because he basically decided that what her gender was at birth was her gender at the date of the marriage, particularly looking at such things as chromosomes, that she had male chromosomes. He didn't take into account psychological factors or hormonal factors or secondary sexual characteristics, and pronounced that a decree of nullity could be granted. Now, while deciding this case, Judge Ormrod looked at what the essential purpose of marriage was. And have a look at that quote. He said, "On the other hand, sex is clearly an essential determinant of the relationship called marriage, because it is and always has been recognised as the union of a man and a woman. It's the institution on which the family is built, and which the capacity for natural heterosexual intercourse is an essential element. It has, of course, many other characteristics, of which companionship and mutual support are important, but the characteristics which distinguish it from all other relationships can only be met by two persons of the opposite sex." So I guess what he was saying there was that marriage was essentially for procreation and to have children, and that could only happen between a man and a woman. As he then says that April Ashley was not a woman within the meaning of the particular Marriage Act, the marriage was not valid. And there's a summary of the reason he used to determine April Ashley's gender at the date of marriage. Now, an Australian case, I guess, dealt with similar themes. This was an application by Kevin to the Family Court of Australia, asking for a declaration of validity of his marriage. I guess it was really a test case, because Kevin had had gender reassignment surgery and wanted to test the law in Australia to see whether the court would hold that he was a man within the meaning of the Marriage Act, our Australian Marriage Act being the Act from 1961. Now in that court, the Commonwealth Attorney General submitted that that previous case we discussed of Corbett was correct and represented the law in Australia, that the same approach that Justice Ormrod took should be taken, and that Kevin's gender at marriage was his gender at birth, which was female, particularly because of his chromosomes, genitals and gonads at birth. His gonads being his ovaries. So that was the submission on behalf of the Attorney General. Now in this case, Justice Chisholm of the Family Court took the view that the approach in Corbett was not the approach to be taken in Australian law. He took a far wider understanding of gender and also took into account psychological factors that Kevin had always perceived himself to be female, and at the time of the marriage perceived himself to be female, and that he had the appearance and characteristics and was recognised by family and colleagues as a male. So during the course of this case, the court again had to look at marriage in Australian law, and the submission by the Attorney General was that, really along the same lines as Corbett, that marriage is a social institution having its origins in ancient Christian law, and it is intrinsically connected with procreation. So another reason why the marriage could not be valid was that Kevin and Jennifer could not naturally procreate, that is, have children. Ironically, at the time of the hearing, Jennifer was pregnant through IVF treatment. However, it was not Kevin's sperm. He was not capable of producing sperm. Now the court, both Justice Chisholm and then the full court of the Family Court, disagreed with the Attorney General's arguments and also with following Corbett. They said that Australian marriage and the law of marriage has its origins in English law and its origins in this Christian beliefs, but it is no longer in Australia confined to the Christian faith. Australia is now a multicultural society. We have many people of different cultures and also different religions. However, we recognise that the origins of our marriage law are embedded in Christian law and beliefs. However, the court said now marriage is secularised, meaning it's separate from religion. It's part of our civil law. They rejected that marriage was principally for the purposes of procreation, and for example talked about some couples are, for example, infertile and can't have children. And they rejected, as we said, that test of gender of Kevin at the time of marriage, purely based on biology and his chromosomes, gonads, and etc. at birth. So that just gives you some idea of, I guess, the origins of our marriage laws, and perhaps gives you a better understanding of the current debates that have been raging about same-sex marriage. And I guess basically the impetus is building in Australia for the laws to be changed and for same-sex marriage to become legalised. There have been many, many attempts to change the law, and I guess on that slide we have the bills presented into Parliament in 2012. They were never passed, and I guess I've just given you the link into the inquiry there, the parliamentary inquiry. If you're interested, that has some of the research done about whether same-sex marriage was something that would be acceptable to the Australian community, and submissions were made. Subsequently in 2013 there was another bill, but that bill lapsed, and again there were investigations made into that bill. Now in the same year 2013 the ACT, Australian Capital Territory, purported to pass legislation making same-sex marriage legal in that territory. Now I guess this was challenged, and it was a constitutional argument, because the argument was that under the Australian Constitution, the Commonwealth, that means the federal parliament, has power to make laws in respect of marriage, not the state or territory parliament, as they purported to do with this Marriage Equality Act. In the subsequent High Court case, the Commonwealth of Australia and the Australian Capital Territory, that argument was successful. The court held that territory legislation could not operate concurrently with the Federal Marriage Act, so it was for Federal Parliament to really decide whether same-sex marriage would become legal and, for example, to amend the Marriage Act. And the territory legislation was struck down. However, interestingly, the judges of the High Court specifically had the view and stated the view that the Federal Parliament, under the Constitution, has power to legislate with respect to same-sex marriage. However, it was for Federal Parliament to decide that. Now again, and I guess this is like a continuing saga, there has been another bill presented to Parliament this year. Nothing progressed with that bill. It was a private member's bill presented by the Honourable Bill Shorten, the Leader of the Opposition. Now, I guess the latest is that there is a proposal that a bill be presented in the spring sittings around August, which will be co-sponsored by a member of the Liberal and Labor Party. And I have posted an article on the Blackboard site from the Australian talking about that bill. So there's certainly momentum building for same-sex marriage, but it seems in some regards now that Australia really lags behind community opinion, because as time has gone on, I guess it now seems that the majority of Australians in polling agree that the laws should be amended for same-sex marriage. And this is, I guess, been particularly influenced by the fact that in many countries around the world, and recently in the United States, same-sex marriage has become legal. And it might be an area where we could say that the law presently is lagging behind community opinion. However, there are many people that still oppose same-sex marriage. So, if we look at arguments against, it's often people because of their religion. And that basis that we looked at in our history, that the essential purpose of marriage is to have children. That a marriage between a man and a woman is the entity that can best support the family and is best for bringing up children. Arguments in support of same-sex marriage are probably based on human rights arguments and equality before the law, that everyone should be entitled to the same laws, whether, for example, they're a heterosexual couple or a same-sex couple, that the law should be consistent and fair and apply to everyone. And also, as I spoke of, the growing support in polling and surveys. In India, there are different arguments that can be put forward under the international law, particularly the Universal Declaration of Human Rights. For example, Article 7, it might be argued that it says all are equal before the law, are entitled without discrimination to the equal protection of the law. So that's an argument for same-sex marriage, that a same-sex couple shouldn't be discriminated against. They should also have the right to marry under the law. However, a contrary argument has been put in relation to Article 16, where it says men and women of full age have the right to marry and found a family. Now, some people would argue, and I guess the way when it was drafted, it would have been the case that it would have meant men marrying women. However, I guess it is open to argument that it just talks about both men and women being entitled to marry. So may also be put forward by some as an argument for same-sex marriage, saying that both men and women, without limitations, should have the right to marry, and they would argue to marry either a man or a woman. So interesting in that regard too. So still, I guess still arguments raging in Australia about those issues. Perhaps now we might be able to comfortably say probably the majority, according to polling, are in support of same-sex marriage. However, on the other hand, there are still many people who don't feel comfortable with that concept. As we said, it is now legal in many different countries, and we've got the slide, and we also set out in the textbook the countries where same-sex marriage is now legal. Another argument, I guess, put forward by some people is that they appreciate that same-sex couples should be able to legally have legal recognition of their relationship, but they don't think that they should be entitled to marry. Some of these people argue that they should be able to register their relationship under the law. Now, this is currently the case in some state and territory jurisdictions, including Queensland, where under the Relationships Act, same-sex couples can legally register their relationship and also have a record of when they've actually entered into their relationship. Now, that actually sometimes becomes an issue in the family court. For example, if people have been in a de facto relationship, they separate and one party goes to court to seek a property settlement, there has been some cases where the other party argues that there was never a de facto relationship. So I guess this type of registration too does give people some sort of legal comfort in that if they ever do separate, there is a legal record of their relationship. So an interesting area of the law. I guess the people arguing that they should have access to registration but not marriage would be arguing that marriage is for a man and a woman and for the purposes of having children. So linked to those religious and historical ideas that we talked about at the beginning of this podcast. Well, that's all for this podcast, and the next one you can go on to is about divorce.